court, and that's a lot of what you're covering too. So, but we're supposed to be about local news too, and things like right. I saw Kathleen Cummings yesterday too.
Okay, right.
So, you can get that. But things like that needs to have a bigger
right.
And that kid in Campbellsport, nobody in civic media responded to that except for me and Jimmy Costa. But that was,
right.
Luckily, and I think because Earl had me on a show to talk about it.
Right. It makes a difference, right?
Yeah.
So in any event, you also thanks so much.
You can also call me later today too. So.
Okay. Maybe I may do that. Yeah, we can just chat. Nothing big.
Our social level too. Did a couple drinks.
This is Amicus, a law review. My name is Jim Santelle, and this is our weekly weekend broadcast, a review of all things related to government and the rule of law, the delivery of justice in America and beyond. Delighted to have you with me both this hour and also next hour on the broadcast stations of Civic Media. We are talking, as always, about the latest events, latest occurrences of the day. Lots to talk about this weekend, like it is every single week. Let me talk first about the reasons for our calling our broadcast Amicus, a law review. Again, we take our name, as always, from the notion that amicus, a legal term, it's derived from the Latin, as you well know, comes from the notion of being an ami, a friend, A-M-I, a friend, an individual, an organization that assists or promotes or somehow encourages some understanding, appreciation of some relevant issues that are needed to be addressed by a tribunal, by a legislative entity. Amicus is a friend of the court, could be a friend of some governmental institution, providing information, insight, perspective, or expertise on something before that particular body. And that is indeed our mission here on our weekend broadcast, but also our weekend broadcast every single week of the year. This is our 99th broadcast here on the broadcast stations of Civic Media. And yes, indeed, an early programming note, and that is that next Saturday on June 8th, a special 100th program, a 100th broadcast, talking again about government and the rule of law, the delivery of justice, but in some special ways, some special features on our 100th broadcast coming up next weekend here on the broadcast stations of Civic Media. This always, of course, involves you as well, our listeners. We cherish, we value your contributions, especially soliciting today and in the future your comments, your questions, your inquiries about things on our extensive, our achievable, our ambitious syllabus as it is every single weekend. That phone number is 844-967-2789. One more time, 844-967-2789, or you can also text us. You can drop a note into our feed on the Civic Media app and be in touch with me and also my terrific producer, Max, who's in the studio here with me this weekend on Amicus, a law review, as we talk about many related topics of our day in the areas of justice, the rule of law, and government as well. Plenty of things to talk about from this past week. And of course, yes, that's right. You anticipated it well. We'll be spending much of this first hour on our weekend broadcast talking about the Trump verdict. Lots of things being written, lots of observations being made, both on broadcast media, but also the written media as well. Lots of things online to consume and to evaluate in terms of understanding what happens. I'm going to be offering this weekend a number of different takeaways from a rule of law perspective. What do we take away from the various aspects of this 6-week trial? What kinds of things should we derive as lessons about justice and the delivery of it in the courts of America, including, yes, that's right, that court in Manhattan, that criminal court presided over by Judge Juan Merchan. What kinds of things should we understand when it comes to the delivery of justice, including the role of prosecutors and defense attorneys, the all-important role of that judge, that presiding judicial officer, and also of the jury itself? We're going to spend some time talking about what all of that means from a rule of law perspective, getting into a bit of the weeds, again, taking your questions as they come up about what happens next, what various things are going to be on the court's docket when the sentencing comes up here in the middle of July. What does that mean? What does an appeal look like? Some nuts and bolts things also for your consumption. All about that. Takeaways from the recently concluded formal part of the trial and conviction of the first president in our nation's history for criminal conduct in a court of our nation. In this particular case, a court of the state of New York. It is a criminal court, again, presided over by a justice or a judge of New York State. Lots of lessons, however, to be derived when it comes to understanding what happened there. Some broad issues I'm going to opine on this weekend, and also some very particular things we can also take up as we understand what has happened and what will happen in the near future. We'll be taking some phone calls as well. Questions, comments along the way that you have had, as you have likewise consumed, as has America. This major event in the history of our nation, that is once again the first time that any former president has been convicted of a crime. We know that Donald Trump previously has been the subject of many pieces of civil litigation, civil judgments entered against him, both by people like E. Jean Carroll and others who have brought civil cases against them. We also know that the corporation itself has been on the receiving end not only of civil litigation and civil judgments of various kinds, the foundation, various things that it has done, Trump University, various business entities. And we also know that the corporation itself has suffered a criminal conviction, the company itself criminally convicted this weekend on Amicus, a law review. What does it mean that now an individual of that corporation, the CEO, Donald Trump, has been found guilty of these 34 counts involving violations of New York state law? What kinds of things can we and should be derived from that, including everything from witness credibility, opening statements, closing arguments, and those events that are yet to come? Beyond that, we are going to be talking about some other major news happening just past week. As always, we talk about the Supreme Court. This is that time period in our nation's history when the Supreme Court, which has about 30 cases yet to decide, even more than that on its docket as it goes forward between now and probably about a month from now, lots and lots of cases to decide. Indeed, it issued another case just this past week involving the NRA and First Amendment issues, NRA versus Vulo. We'll talk about what that case is all about. And yes, necessarily, we're going to talk yet again about ethics on the Supreme Court, focusing in part upon Justice Samuel Alito, some latest developments in terms of his not only flying flags, but also following up on a discussion of our last weekend broadcast about the reasons why Sam Alito should not only be recused with respect to at least 2 cases that will be the subjects of some of those opinions to be issued in the next 3 to 4, maybe 5 weeks at the outside. He should be recused. Absolutely. That is the lowest common denominator. That is the easy thing that needs to happen here. Stunned that we are still debating whether recusal is appropriate. My advocacy, as you well know from previous broadcasts, is because of the cynicism and the lack of respect and the contempt that he's had for the basic institutions of the very government of which he's a part. Sam Alito needs to be off the Supreme Court. He needs to resign this morning and other times during the course of future broadcasts. We're going to be talking about additional ways in which to understand Sam Alito based upon things he has said to litigants before him, things he has commented about and observed with respect to his own associate justices on the Supreme Court, and even things he has said in the public domain. A major speech that he gave a number of years ago for the Federalist Society that is shocking in terms of the kinds of things that he believes and articulates openly. I'm going to talk about the Supreme Court a lot again on our weekend broadcast. this time around. We've got some other news coming out of elections in South Africa. South Africa, the election results still coming in there. Will the African National Congress, which has been in power for 30 years since the fall of apartheid, will that continue under its present president? We're still awaiting the final results. It looks as if there could be a major change, not just politically, but in terms of the rule of law in South Africa. We also will be talking about what's happening tomorrow in this weekend in Mexico, a major, major election of the leadership there in our nation, just to the south of our nation. That is probably the first time in Mexican history that the Mexican population about to elect a woman. We'll talk about that election coming up. Yes, they will beat us to that important milestone in history. The first time that Mexico almost certainly will be electing a woman to its top position. We'll talk about that as well, in addition to elections going on generally. Other things coming up during the course of the week, always important for your questions and comments as well. Finally, in our last segments of this 2-hour broadcast here on Amicus, a Law Review, we're going to spend some special time articulating our commitment, as we always do, to civil rights and to the importance of human rights in America, as we have done in many other circumstances: voting rights, housing rights, basic liberties, privacy rights under our Constitution, now under attack in the wake of the decision in Dobbs. This is also Pride Month, when we recognize specifically the privacy rights and the same-sex relationship rights, the rights to marry of our LGBTQIA populations in our nation, including right here in the state of Wisconsin and beyond. Some special segments at the end of our weekend broadcast. We'll be focusing on the 10-year anniversary of marriage equality in Wisconsin. Recall well that in 2013 and 2016, the United States Supreme Court issued some major cases, one of those called Windsor, another one called Obergefell, both of them redefining, again, under a privacy right rubric, the things that are implicit and explicit in the Constitution of our nation. That is the right of same-sex couples to marry. Even before that was happening in 2016, a 10-year anniversary today celebrated what happened in Wisconsin in 2014. We have some special guests talking about the litigation that was pursued successfully in the federal district court in the Western District of Wisconsin, which is Madison venued, a decision by U.S. District Court Judge Barbara Crabb, and the litigation that followed in the Seventh Circuit. We have some special guests coming on in the final segments of our second hour, talking about their role as plaintiffs in that particular case, the significance of what they have done, not only in terms of advancing civil rights, human rights, privacy rights in America, but their continuing commitment to that. We're going to talk about some special events coming up in Milwaukee having to do with Pride Fest at the end of this week. All of that coming up on Amicus, a Law Review, here on the broadcast stations of Civic Media. Always, as I indicated, inviting your questions, especially your comments, your inquiries about things that are on that very ambitious agenda that we have this weekend. Max and I encouraged to and always taking your phone calls, your texts about those issues that animate the rule of law and justice in America. Let us begin then with the principal news, the major history of our nation, and that is that during the course of just this past week, the court did in fact return a verdict, a judgment by the jury, finding that Donald Trump is guilty of 34 counts of violations of the law of the state of New York having to do with financial matters. 34 counts based upon some checks, some registry entries, and some invoices that were all put together to accomplish a larger purpose, which, yes, was in part to complete a conspiracy, a plan to keep people quiet, including people like Stormy Daniels and Karen McDougal, but more largely, more broadly speaking, to affect the 2016 election. The reason why this case is so very important, it is an election interference case. And as we continue, we will talk more about that right here on Amicus, a Law Review.
There is one caller and another one that said he would call back later. Already,
Okay.
so.
All right. So Larry's on. I probably won't take him right away, but we'll get to him probably later in this hour. That sounds good. All right. Good. This is Amicus, a law review on the broadcast stations of Civic Media. Delighted to have you joining me and my producer, Max, to talk this weekend all about justice, about the delivery of justice, the administration of it, the delivery of it specifically in a court in the state of New York. You know the issue very well. You know the news story, and that is that on Thursday, a jury of 12 people found unanimously, that the government had in fact proven its case beyond a reasonable doubt against Donald John Trump, the first president in our nation's history to go to trial and defending against criminal counts, 34 criminal counts alleging violations of New York state law, yes, having to do with finances and documents, but also having to do with a whole lot more, which is an attempt way back in 2016 to deprive the people of not just New York, but of every state in the union of information, relevant insight into who he was and some part of his history related to his past sexual relationship, at least with Stormy Daniels. And because of that, because of the financial transactions by which he caught and killed, if you will, captured that particular story, hushed it up, an allegation, an overall thematic charge by the prosecution that this was indeed about election interference, an attempt to stop people from in America, from knowing all about what's going on in this particular campaign, this particular election. We have talked a lot on previous broadcasts of this show about the content of that, about the reasons why this was and remains in the end an incredibly powerful case. And that is indeed where I begin with my commentary this weekend. Many different takeaways from this trial, the conviction, and also talking about what goes forward. First, we have chatted a lot about the notion in America of relying upon experts, people who know what they're doing. We know that in the political campaign right now, at least from Donald Trump and others as well, there is an attack on something that doesn't exist, and that is called the administrative state. This notion that somehow out there are people who are engaged in all sorts of conduct in our federal, arguably our state agencies as well, who are operating on your behalf, and we know nothing about them. We don't know that they are responsible to us. We don't know what they're doing, and somehow we've got to rein that in, specifically suggesting that they don't know what they're doing. It is a lack of reliance upon the experts. It is a lack of reliance on the scientists, of the people who are experts in their areas, the medical people, the architects, the teachers, the academics, the financial people of our worlds, all the people who engage in expertise, all of that under attack in America politically, and also, as we know, anticipating sometime in the next few weeks, two major decisions coming out of the Supreme Court that also address that issue. Now, why am I talking about that in connection with the Trump trial? And the answer is that this was expertly done. This presentation by this prosecution team from start to finish exhibits exactly what you get when you have people in positions of responsibility and authority in whom we have entrusted the delivery of justice, who know what they're doing, who have the expertise. In this particular case, that expertise happens to be legal, it happens to be prosecution, it happens to be premised upon experience and knowledge about how cases work. And I would offer as a first takeaway observation about what happened in recent weeks, including the verdict of just a couple of days ago, that the reason why this case resulted in a conviction of Donald Trump, yes, indeed, the evidence was there. But beyond that, it was done expertly. It was presented in a logical way. It was presented in a way where there was structure from the start, from the opening statement that laid out exactly what the jury was going to be hearing about, and the witnesses coming before them. Management of those witnesses, some of whom, as we indicated, have had huge baggage. The people like David Pecker, this journalist who plainly revealed to us a way in which journalism, at least in his part of that world, works today. Not an especially attractive understanding of journalism, and nonetheless presented as a credible witness for the things that he was describing. Stormy Daniels herself, also having baggage. We'll talk more about the specifics of what she did and why she was also managed well, prepared well, not rehearsed, but managed well by the prosecution. And of course, Michael Cohen as well, similarly put together and presented to this jury for what he was, nothing more, nothing less, with all of his baggage, expertly well done. A closing argument that, yes, indeed, lasted 3 hours by the expert who is presenting the evidence, summarizing all of it for the jury, making sense of it, bringing together 5 weeks of testimony so that they could understand it as they go back into the deliberation room. Putting that all together, the point is expertise, legal expertise in this case. The broader takeaway is an appropriate level of expertise, doing what they are assigned to do, and government, regardless of our view about the evidence itself, government relying upon people who know what they're doing. Just as in these other areas of our present examination, the challenges out there, including these 2 remaining cases before the Supreme Court, suggesting that people in government don't know what they're doing and that the experts are not to be trusted. I would offer to you that the first takeaway is that this trial represents what happens when you do indeed put people not only in these positions, but vest in them the authority to do their jobs well. When you've got experts doing it, again, in this case, legal expertise, you can in fact accomplish justice. The rule of law is supported, as it would be in all those other agency areas where those things likewise happen. Expertise, something to be embraced. A second major aspect of what we pull away from this trial and this verdict of just recent times, and that is something else that we have talked about a lot, not only in connection with the Supreme Court, but all of these other rule of law issues that we have talked about in great detail. And that is the notion of critical thinking in America. One of the great concerns that I suspect many of us have, I know that I do myself. The reason why we have this broadcast, the reason why we call it Amicus, a law review, to be a friend of not just the court. They don't necessarily need to hear from me every weekend, but to inform our population, to provide information, insight, perspective, all of that to support what? To support critical thinking about the issues that we are identifying. Yes, issues inside of legal things, legal matters, justice, trial proceedings, the rule of law, critical thinking based upon facts and understandings of what we know the rules of the law to be, that we know how structures are put in place and how they work. I would offer that the second major takeaway coming out of this trial, and especially this conviction of just a few days ago, is that you have a jury here that engaged in exactly the kind of critical thinking, a reaffirmation that in America in 2024, there are people, and this, they're not just in New York, they're throughout our nation, in Wisconsin and beyond, in every single territory, in every single state, who still do have that capacity to do what? To understand the facts, just as this jury did, understanding what the testimony was, what the documents said, looking at the basic predicate information before them, and then applying through processes of critical thinking what the law requires from those facts. What are they supposed to take away? And the other indications, the other things that I applaud about this, again, not only the expert presentation by the prosecution, but this jury as well, doing things like taking notes copiously, trying to understand again what the facts are, not relying simply upon gut senses or some emotional response to what they're hearing, but taking down notes that presumably memorialize things going on, the facts of what's happening in that trial. All of that, a part of the critical thinking underway by this jury. We're going to talk more about what that means, not only probably in their deliberation, but what the nature of their response was to that, and how, once again, we look to that jury and say a good example of critical thinking in America here as our discussion continues on Amicus, a law review.
Got about 5 minutes. Somebody called in with a question.
Okay,
Bud from Janesville.
Bud. Okay.
Um,
Remember what the subject matter was, or
it was how the Republicans are interpreting the Trump cases. I believe.
okay. We're going to get to that. Good,
So I
good.
figured as much, but
Yep. Good, great. I will make reference to him. I'm going to go another probably segment. We'll probably do some calls, maybe the last segment.
well, this next one is 15 minutes.
Okay,
So if
okay.
but yeah, whatever you want.
Okay, good. I'll make reference to Bud. I'll probably call Larry up maybe at the end of this next segment,
Okay.
maybe in the first part of the next, the final one. Good,
Sounds
great.
Yeah, you're good.
This is Amicus Law Review. My name is Jim Santelle, your host for this hour and next hour as well on our weekly review of all things justice related here on the broadcast stations of Civic Media, talking principally in this first hour all about the major news, the major history that happened in America just this past week. That is the criminal conviction of a former President Donald Trump in that Manhattan courtroom. Some larger takeaways from the trial about which we have spoken at great length in previous broadcasts, focusing initially upon the expertise of people in government and what you get, which is a result that is rule of law based, that is credible, that is competent when you have experts in these positions of responsibility. That was the prosecution team here. Now talking about the role of the jury and likewise reaffirming this notion that in America, we do have people who are able to and still do engage in the critical thinking. The best illustration of them just this past week, that jury that was taking notes. Why? Because they wanted to get the facts right. They wanted to make certain that their own memories were correct when they went back into that jury deliberation room. Interestingly, the only member of the jury who was not taking notes was the foreperson himself. Not to be critical of him, but all of them attentive, and other things that indicated that they wanted to get this right and that their critical thinking skills, which are important to every aspect of our lives, including government today, understanding what is real and what is not, understanding what is fake out there, what is false, and what is true. That's what this jury illustrated just this past week. They took notes, and when they asked for specific instructions, what did they ask for? They asked for things that made it clear that their deliberation was likewise focusing upon things related to analysis and comprehension of what had happened in the previous weeks. They asked for the testimony of two people. Who are those two people? One of them, David Pecker. Who did he do? He was this fellow who came in and talked about as his role as the publisher of the National Enquirer. He provided the overall structure, the superstructure, if you will, for everything that he heard. He was the first witness, and probably when jurors were first listening to him, they did not have all of the insight about where this was going, even though they did have the benefit of a very competent opening statement. Nonetheless, they wanted to hear it from him once again. They wanted to hear a recitation of portions of his testimony because that was the structure upon which everything else was based. That suggests to me quite compellingly that this was a jury, again, focusing upon facts, focusing upon getting it right, doing that critical thinking, and trying to make sense of all the testimony, including that of the lawyers and the various technicians and the documents custodians. And yes, indeed, Stormy Daniels and Robert Costello and Hope Hicks and Michael Cohen, all the others. How does that fit? They wanted to hear more about that because it indicates that critical thinking analysis. Likewise, testimony we read from Michael Cohen, a very key witness in all of this, making certain that they understand, not just based upon their notes, what it was he expressly said, and then a couple of other indications that they understood what their role was and did it, again, expertly, applying the thinking skills that all of us should have when it comes to every issue, whether we are in a jury or not here in America in 2024. They came back and they said, Judge, we'd like once again to hear your rainstorm or your rain instruction. That may strike you as sort of odd, but the reality is that during the course of his instructions to the jury, this omnibus statement of what the law is, the judge basically described the difference between direct and circumstantial evidence. And he said, and this is an important takeaway as well, not only from this trial, again, where the compelling evidence produced a just result, a very well done prosecution that was airtight and solid, the difference between direct and circumstantial evidence, and here's the point, and this is what the judge instructed them on, which is that circumstantial evidence, even though it sounds less compelling, can be just as compelling as direct evidence. Direct evidence, the things that you see, that you hear directly, that you consume as a human being through your own senses, and yet an awful lot of things when one thinks about it. Our lives are premised upon circumstantial evidence. And he gave them this example, which they wanted to hear again because they understood that some of this case was premised upon circumstantial evidence, not direct evidence, but circumstantial evidence that leads nonetheless to a finding, again, beyond a reasonable doubt, that this defendant had committed these crimes. And the judge described once again a rainstorm. And he said, among other things, that if you come out from an office into a hallway, even you come out onto the street and you see that the ground is wet and that the trees have water dripping from them, and people are walking around with umbrellas, which may be open or closed, you're going to surmise, you're going to come to the conclusion that a rainstorm just happened. Even though you were not there for the rainstorm itself, you cannot say with direct evidence from your own eyesight, maybe even your own ears, that a rainstorm happened. All of those indications are that it just rained. It's on the ground. It's in the umbrellas. It's in the trees. Maybe people are even scurrying still to get dry. All of that circumstantial evidence that clouds just came in and rain was dropped from the sky. That's the kind of thing that the jury wanted to hear in understanding how it was supposed to interpret the circumstantial evidence. And again, here's the evidentiary piece from this weekend's Amicus, a law review, which is circumstantial evidence is no less compelling than direct evidence. It's simply a different kind, and that's what the judge was instructing them on. And that is what the jury wanted to hear. Those are people, I would offer to you, who are doing the job they were assigned to do, doing it well. And again, to double back and talk again about the prosecution and the expertise there, an awful lot of concern, of course, about whether or not this was a jury that would take its task seriously, whether there were people there who were going to find no possibility of convicting, even though the evidence may suggest that. Plainly, the prosecution and the people that they were looking at from that entire hundreds of people veneer, the prosecution once again did an expert job. They put 2 lawyers on the jury. Normally, you wouldn't have that happen. Why? They saw in those people, again, the 2 and frankly, all the others, including the alternates, people who could bring to this some analysis, some understanding, who would understand the difference between direct and circumstantial evidence, who would take notes, who would come back then and say that we now have to go through the evidence, which they had time to do, about 9.5 hours of the review and deliberation. They did all that in a methodical way. We do not know, and perhaps we'll never know exactly the course of that. But the fact that they returned this verdict in a timely fashion and yet not immediately suggests strongly they took their job, their assignment, the instructions given to them by Judge Juan Merchan seriously, critical thinking going on in that courtroom, and expertise inside not only the prosecution, but also that jury as well. A third major takeaway, and that is the trials are about storytelling. Storytelling. We tell stories, and indeed, both the prosecution and the defense told stories. I do not mean that in an inappropriate or critical way. They tell stories about what the evidence will show, the documents will show. They did that during the course of opening statements, very conflicting opening statements, and especially they did that in the course of their closing arguments, doing things to bring together all the evidence that the jury heard and consumed over the previous week. Often said that trials are like theater, and indeed they are. You are presenting a story for consumption by what? An audience. In the case of a trial, it happens to be a jury that's deliberating ultimately upon the credibility of witnesses. The same way that when you are in the theater, you look at actors or actresses playing roles, to be sure, and yes, reciting lines from a plan, a script, if you will. But nonetheless, you assess whether that person is likable, unlikable, whether they are good or evil, all those kinds of things that we see all the time in theater. I would offer that that same sort of thing goes on in trials, where you've got a jury that likewise is watching the stage of this story as it is played out. The significant difference, of course, between theater and a trial is that in theater, even though, yes, there's antagonism, there are protagonists and antagonists, and you've got conflict, and that's what makes interesting theater. Nonetheless, there is still one script, and all those actors, as you all well know, are reciting their lines and hitting their marks and investing in their parts some sense of humanity and drama based upon a unified script. It's all off of one script. In a trial, the theater is scripts competing. And that's what you saw once again in this trial of Donald Trump. You saw a story being told by the prosecution, a story, some promises made during the course of the opening statement that were in fact met. And during the course of the 3-hour closing argument, prosecution apologized at one point for going on, but did not really indicate that that apology was based upon simply going too long, but wanted to be meticulous in that expertise. all of that, telling the story of what the evidence had shown. The defense also, with less to work with because of the nature of this case, the fact that the singular, actually there were two witnesses for the defense, but the singular witness for the defense, his name, of course, Robert Costello, not compelling. The jury saw that as well. Defense doesn't have nearly as much to work with in this very, very composite and very compelling case, but nonetheless, they told another story. They told the story, apparently, according to much of what the principal attorney for Donald Trump is saying now in media, a story that Donald Trump wanted them to tell about the fact that this affair with Stormy Daniels never happened, that of course he never understood anything about any of these documents. He did not intend to engage in any of the fraudulent conduct alleged. A story that competes on that stage of the jury trial with the story told much more compellingly by the prosecution. Along the way, again, we have witness credibility. We've talked a lot about Michael Cohen. We've talked about David Pecker. We've talked about Hope Hicks and the others. One specific highlight in terms of this concept of storytelling, which was compelling for this jury, expertly presented by the prosecution, and that is putting aside all of the other remarks by Stormy Daniels, very much pushing back on the allegations that she herself was unbelievable, not credibility. Arguably, my favorite and my most compelling statement of the entire trial, the thing you take away in terms of a rule of law understanding, a civics understanding, an evidentiary understanding, was when she was confronted by the defense attorney who was saying to her that she was making all this up. None of this happened. It was not real. And in fact, she is a part of an industry, the pornography industry, that makes this up generally when it comes to these kinds of stories. And along the way, in addition to her denials, Stormy Daniels said this. She said, "No, counsel, no, I'm not making this up." She said, "If I was going to lie, if I was going to make all this up, I would have made up a better story. I put together a bigger lie." That's not exactly what she said, but she's put together a bigger story. And indeed, that also is about the storytelling here. She tells you a story that is not as dramatic as it could be, and she tells you that she could have come up with something even more outlandish, more outrageous than what the truth was if she had the time and the inclination to do it. She says she's not doing it because she's not testifying falsely. She's not making up that better story that arguably could have been about, for example, a rape, a sexual assault, of the sort that E. Jean Carroll described in the trials that she had with Donald Trump. That's not what Stormy Daniels did. She told a story that was based upon truth, a story that if she wanted to make it up, if she wanted this theater to be even greater than it was, she could have done so. If she was going to lie, as she said, she would have done even better. She didn't do that. All of that focusing upon the storytelling that goes on in this trial. Closing arguments, compelling presentations again by the prosecution over a period of 3 hours, including some very specific demonstrations about how this all-important phone call that was made by Michael Cohen to the security people, this fellow to whom he was reaching out, a 96-second phone call that the defense made a lot of. The allegation that Michael Cohen could not possibly have been discussing not only this effort to try to get a 14-year-old to stop harassing him, but also the very subject matter of this trial, the allegation that this 90-second phone call could not have included all of that. What is the storytelling? What is the drama? What is the theater that happened by this expert prosecutor during the course of closing argument? What he did was he described in a theatrical way exactly what that phone call could have been all about. And he provided some admittedly made up, if you will, not completely fictitious, because it was premised upon what Michael Cohen said, but we don't have a transcript of it. So he filled in those component pieces of it and described and basically engaged, as Michael Cohen did during that call, in the kinds of things that he would have said to the security guard. Turns out that as he did that during the course of closing argument, the theater, this compelling presentation on the stage of this trial, turns out that the conversation that he had was 49 seconds in length. Very, very compelling testimony from Michael Cohen, supported then in the closing act, if you will, of this theater, of this trial, the closing argument from the prosecution. A few more perspectives when we come back here on Amicus, a law review, talking all about the Trump trial and the conviction. This is Amicus Law Review. My name, Jim Santelle, your host this hour and next hour as well, necessarily, appropriately spending a huge amount of time on our weekend broadcast, this time around talking about what I see as some major takeaways, some broad issues coming out of that trial and that conviction of Donald Trump just concluded this past week. Let's talk about some nuts and bolts having to do with the sentencing and appeal, and then some final comments about what all of this means in terms of the tragedy that is indeed criminal prosecution of not just this case, but all cases involving criminal prosecution. We know that the judge has now set July 11th, right before the Republican National Convention, July 11th as the time for sentencing. What's going to happen between now and that particular proceeding before him? Lots of different things. The probation department, and again, an office of the government, an office of the court there, not the prosecution. This is not the executive branch. No, this is not the White House. It's not Joe Biden. It is a branch of the court, is going to be talking with Donald Trump and assembling information for the judge to rely upon during the course of the sentencing coming up on the 11th of July. And what kinds of things will that report include? It will include things about the history of Donald Trump, where he went to school, his family, his financial records, all those things relevant to the judge deciding how best to impose a sentence in this case. The judge can necessarily, if he wants to, he can rely on things far beyond the prosecution itself. Yes, he can rely upon those previous civil and criminal prosecutions that implicate both directly and indirectly Donald Trump. He can make reference to those. He can make reference to the defamation judgments entered by other juries there in New York with respect to E. Jean Carroll. He can make reference to the civil cases, including the Attorney General's case, that whopping hundreds of millions of dollars fraud case. He can talk about that. He can talk about other things beyond the trial itself. Why? Because all of those are related to the effort to try to accomplish the best sentence possible. The defendant, Donald Trump, also required to, he can decline to talk if he wants to, but to his benefit, to talk to a probation officer, providing his own view, if you will, of what happened here, his own perspective on how he should be sentenced, all of that put together in terms of a recommendation to the judge. What can the judge do? He can do many different things. We know that each of these counts carries with it a sentence of up to 4 years. That's not to say you multiply 34 by 4 and come up with the term of imprisonment. That will not happen. Likely, if there are sentences of incarceration of some kind, those will be concurrent with respect to each single count. And again, based upon the history of these kinds of prosecutions in New York, if there is indeed some incarcerative period, it will be limited. Maybe to days, maybe to weeks, maybe to months. It will not be a huge amount of time based upon the fact that this is still a defendant who has not previously suffered any criminal conviction of this type. But also the judge, as I indicated, can take into account these other things. And you will recall well that during the course of the trial, he also, that is the judge, found Donald Trump in contempt of the court for his violations of the so-called gag order, this thing that I hesitate always to call a gag order because Donald Trump was not being gagged, but the determination by the trial judge that Donald Trump was saying repeatedly things out there in the public domain that he should not have been saying. The judge can consider that as he admonished Donald Trump during the course of the trial. He can say that I'm considering that in part in imposing the sentence upon you for the criminal conduct of this conviction. Lots of things to take into account. And the recommendations obviously would include not only recommendations from the prosecution about what should happen here, probably filing a sentencing memorandum sometime before the 11th of July, setting forth what that recommendation would be. Defense has an opportunity also to make a recommendation, almost certainly suggesting that the defendant should suffer no jail time, that perhaps probation and not even a fine should be imposed. The judge also has that option as well. The judge can do lots of different things when it comes to that sentencing. And at that sentencing as well, not only does the court hear from the prosecution, hears from the defense, but also, yes, indeed, affords the defendant, in this case, as in every case, the right of allocution, which is a fancy lawyer way of saying you can talk to the judge now about your position on what should happen. And one of the things that the court can take into account is whether or not Donald Trump is remorseful. Certainly the statements that followed immediately after the return of the verdict, this major press conference that he held just on Friday in the morning, all of that indicating that he is doubling down on the notion that he thinks that this was a sham trial, that everyone was corrupt, that the judge was inappropriate in terms of his conduct, and everything was wrong about this. The judge can take all of that into account in imposing the sentence. And yes, indeed, after that is done, sometime after July 11th, when the final judgment is entered, Donald Trump does have a right to take this up on appeal. Highly unlikely that pending that appeal to the appellate courts in the state of New York, that Donald Trump would be incarcerated, that the judgment would be made final and that would be executed on, whatever that may be, whether it's probation, some home arrest, some other kind of limited detention in some kind of a facility. Highly unlikely that that will happen before the exhaustion of all the appeals, which will go on probably for months, maybe even years in the appeals courts in New York. Not to diminish in any way the significance of this major judgment entered by the jury, this major finding by the jury of a set of criminal conduct engaged in by this defendant beyond a reasonable doubt. And that's the premise not only for the sentencing coming up, but for the further proceedings that will indeed be testing whether or not what just happened can be upheld and withstand the scrutiny of further appellate review. My own view is yes, it will. Not to say that there will not be arguments about various things, the jury instructions, the credibility of witnesses, the closing arguments, all kinds of evidentiary determinations, but all of that in the end, the prediction that one day there will come a time when the appellate court will find that indeed this was a trial that delivered justice. Rule of law, for all the reasons discussed up to this point, followed, justice delivered and administered by the judge, by the prosecution, yes, by the defense as well, and especially by this jury, in making sense of these charges and bringing to a conclusion this major component, the big component of this case. All of that, a part of the rule of law disposition this week. As we go ahead and continue into our second hour here on Amicus Law Review, one or two final comments just about what are we to take away from this? How do we understand this broadly? Not only about other statements being made in the public domain, but also, again, about the tragedy that America suffers in the wake of this conviction and continues to suffer as a result of all of this. Also taking phone calls and comments from you here on Amicus, a law review.
Back in like 7 minutes.
I'm sorry?
I said we're back in like 7 minutes.
Okay, great. Thank you very much.
Ready?
All right. Yep.
Coming back.
Okay. This is Amicus, a law review. My name is Jim Santelle. I am your host for the second hour of our weekend broadcast, talking all about law and justice, the administration of justice, the delivery of it. Just this past week in a criminal courthouse, a criminal courtroom in Manhattan, talking, yes, about the trial and the conviction by a jury beyond a reasonable doubt, finding that indeed the prosecution had met its burden, finding that Donald Trump had engaged in criminal conduct, 34 counts of conviction, felony counts of conviction under New York law, talking about some of the big takeaways, a couple of more in connection with that. One of them, of course, is this notion that somehow Donald Trump has been mistreated and not treated fairly, as would other defendants in America. In fact, just the opposite is true. Judge Merchan has bent over backwards. Judge Merchan has ensured that this defendant receives all of the protections, procedural, substantive, that would be afforded any defendant in America, in federal court, in state court, in local courts, and this continuing notion articulated by, yes, Donald Trump, and yes, indeed, many others, that somehow this was not the delivery of justice, that somehow this was corrupt, that this was a sham trial, a witch hunt, once again, completely unfounded, completely unsupported by the basic process of this case. Donald Trump afforded every opportunity to cross-examine all the witnesses, afforded the opportunity through his counsel not only to make opening statements, closing arguments, afforded the opportunity, as Judge Merchan indicated, if he chose to do so, to testify on his own behalf. Some of the Donald Trump continues to suggest somehow he was prevented from doing, that somehow during the course of the process in this case, things went awry and he was not permitted to present his case. Simply untrue. All of that, of course, about the continuing statements, extrajudicial statements being made about what happened here, not only from Donald Trump, but others as well. They are legion, and they are all wrong. Especially troubling, again, another big takeaway from what's happening right now are representations, statements made by other people in government about what has happened here and not what's happened here. I'm going to highlight just two of them. One of them is the Speaker of the House of Representatives, who, yes, was there during the course of the trial on at least one day, with many others claiming that this trial was a sham, that it was not, in fact, the administration of justice. Indeed, after the return of the verdict, Mike Johnson, third in line for the presidency, the Speaker of the House of Representatives, said this. He said, I do believe that the Supreme Court, he's talking about the United States Supreme Court, should step in. He said that Donald Trump was falsely found guilty, inappropriately found guilty of these criminal charges. He said, this is totally unprecedented and it's dangerous to our system. He went on to say, this is diminishing the American people's faith in our system of justice itself. And to maintain a republic, the speaker went on, you have to have that. People have to believe that justice is fair and that there's equal justice under the law. The justices on the court, I know many of them personally. He's talking about the Supreme Court. I think they're deeply concerned about that, as we all are. And then went on to say, this will be overturned, guys. There's no question about it. It's just going to take some time to do it. Mr. Speaker, no, completely wrong. Completely false in terms of what happened here. Your representations to America and to everyone who would listen in your bully pulpit, which you do have as the speaker, suggesting that the rule of law was not followed here, that the process of judicial proceedings affording the defendant all these rights to be heard, the continuing assumption, the presumption that comes with him until the time of the return of the jury verdict, that he is innocent until proven guilty, all of those things properly done, not at all a sham trial. And indeed, if you are talking to Supreme Court justices right now, Mr. Speaker, about the possibility that one day they may review a final decision by the highest court of New York, that too is improper, not only for you, but also for the Supreme Court justices themselves. All of that by Speaker Johnson in the wake of the return of the verdict, completely inappropriate, irresponsible, reckless, wild, and certainly stirring up exactly the kinds of things that we do not need in this country right now. Offer that Speaker Johnson should be quiet And while he does not necessarily need to embrace the verdict itself, what he should be saying is, we respect the verdict. And that is indeed what precisely one governor, Larry Hogan, has said, that we respect the verdict, and that's our system. And of course, Larry Hogan on the receiving end of many, many pieces of criticism and other attacks, alone virtually in the Republican Party for taking that most appropriate view. There's a second one I'll also highlight, also coming from the Congress itself. Susan Collins, senior member of the United States Senate, criticizing the political underpinnings of the lawsuit. Susan Collins going on to say that indeed, the lawsuit, just as Mike Johnson has said, is not to be trusted. The verdict is not to be trusted. Susan Collins, a senator of the United States of America, who has previously condemned Donald Trump for many of his actions, including January 6th, now suggesting to the American public in her bully pulpit that this process was not adequate, that it did not guarantee this defendant all the rights that he was in fact guaranteed under New York law and the Constitution, equally irresponsible, reckless, wild, and should be condemned by anyone who is listening to and digesting what Susan Collins has said. I know that Bob has called in from Janesville talking about many of the things being said, interpreting this verdict. Bud, that's exactly your comment, your question about this. That is exactly what Americans should be animated about, in addition to the very good things that came out of this legitimate, decent process. The recasting, the recharacterization of this is something other than that by people in positions of responsibility is once again irresponsible, reckless, and should be the subject of condemnation both publicly and privately inside the halls of Congress and by the constituencies who call upon those people to provide leadership. They're doing nothing of the sort right now. Final comment then about all of this. It goes back not only to these issues, these articulated misstatements being made by the Susan Collinses and the Mike Johnsons of the world, but also by Donald Trump himself. And that is that all of this, of course, is human tragedy. We've talked a lot about that in the past, that anytime a defendant goes to trial, it is human tragedy. It is necessary. I prosecuted cases for 30 years in the federal courts of the Eastern District of Wisconsin and elsewhere. And although it is absolutely critical, I believe in that process. I believe that there are times when indeed a grand jury does need to indict people for their violations of the law, federal law, state law, based upon probable cause findings. The juries do, in fact, need to assess the legitimacy of the evidence presented before them and find those defendants guilty. Why? Because that's a part of our administration of justice that ensures our own safety and security. That's what that's all about. It is a process that necessarily includes defense attorneys who are going to test the legitimacy of those presentations. We're going to suggest to juries, argue to juries appropriately, strenuously. The government has not proven its case. Did that for 30 years. That's a part of the process. Nonetheless, I would offer that at this time, in the wake of this catastrophic event, this tragic event involving Donald Trump in American history, there's nothing to celebrate here. This is not a reason for celebration. It is a tragedy for all Americans. It is a tragedy that in the middle of 2024, as we should be focusing upon other issues related to education and commerce and immigration and foreign affairs and all sorts of other things out there, we are instead focusing upon the criminal conduct of a former president and someone who's also running for the presidency right now. It is a tragedy for all Americans that we are doing this. It's a tragedy for those people who are victimized in this trial and in other trials, civil and criminal, by the conduct in which he is engaged. This is a tragedy for everyone involved in this. Nothing to celebrate, recognizing the legitimacy of the result, acknowledging the expertise not only of the prosecution, the critical thinking that came to this result, understanding that all of that is a good codification, an outstanding illustration of how justice should work in America, and embracing that and being pleased, that's the word, pleased about what has happened here because it is an illustration of the rule of law, but also recognizing the tragedy of this prosecution going forward. And yes, I'll also say this out loud. It is a tragedy for Donald Trump and indeed his family as well, that this person who was put up in life to have financial success, education success, made these decisions, not only here, but plainly in other cases that sent him down a road of criminal conduct, brought his family along with all of this. It is a tragedy for him as well, and that tragedy continues, even as he is sentenced in the middle of July, even as America continues to wrestle with the tragedy of Donald Trump and these other cases also going forward. Conduct in violation of the basic norms, the standards by which we live and work and breathe and get along with each other. That's what all of these cases are about. Criminal prosecution and many types of civil prosecution tragedies. And that is what we continue to suffer, even though we are pleased and we recognize and we embrace the legitimacy not only of the process that brings him to justice finally, but also a process that is right and decent based upon what the jury has done, the judge has done, defense counsel has done, prosecution has done, and all of the others who supported this effort. It's like Macbeth. It is like Othello. It's like Richard III. Tragedy in many ways in America. Appreciate, as always, the comments and questions of all of our callers, including those who come in and present us with notes and comments along the way. All of that related to the trial of Donald Trump. Much more of that down the road, obviously, on this broadcast and others, as we continue to analyze and think about what this means, not only with respect to the present campaign for the presidency, but also the future of America, trials, justice, the rule of law, and the delivery of justice going forward. We've talked at great length about the United States Supreme Court. Indeed, Mike Johnson seems to invoke the United States Supreme Court in his recent comments, suggesting that one day they need to get involved and do this as well. I'm going to spend some time in the next segment or so talking more about something the Supreme Court itself did in another area, a First Amendment, Second Amendment case. Talk a little bit more about what you can do if you are concerned about the Supreme Court, not only Sam Alito and Clarence Thomas, but what you can do. A caller last week talked about the efforts and the initiatives that could be taken in reaching out. We're going to talk more about that in our next segment. And then in our final segments of this broadcast this weekend, we're going to turn and move to the other major events coming up this month, and that is Pride Month in America, as we continue our discussion here on Amicus, a Law Review. I was actually just about to go to him. Did he dropped off?
Yeah.
Okay. Ugh. Right.
I haven't screened that other one yet.
Okay.
There were two people asking from both text and stream comments about Trump's limit on travel.
Travel. Okay.
with
Yeah.
other countries. One person
Okay.
was asking specifically about Scotland.
Yep.
Through the text line, so I don't know how much more. You want to
Okay.
talk about that.
Yeah.
But-
I mean, I do that, but okay, that's good. But the other fellow, there was somebody else coming up here.
Yeah.
Okay. Well,
I'm gonna
all right.
get a screen
All right.
share.
We'll see what.
I'll do that after we start. This.
Great. Thank
Yeah,
you.
probably.
Good. This is Amicus, a Law Review. My name is Jim Santelle. And yes, we're in our second hour of our weekend broadcast, talking principally today, necessarily, appropriately, about this major event happening in American history, in American rule of law. That is the conviction of Donald Trump just this past week. Some large takeaways having to do with expertise in prosecution, critical thinking by a jury, the storytelling, this theater, which is not in any way to diminish the significance of that storytelling that results in this finding beyond a reasonable doubt that Donald Trump is guilty of these 34 counts. The inappropriate statements made about what in fact happened in that court, presided over by Juan Merchan, the inaccurate statements, the misleading statements, the politically irresponsible, the governmentally irresponsible and reckless statements made by people, not just Donald Trump, but other people in positions of authority who know better and who nonetheless are providing the American population with reasons to doubt the legitimacy of our processes. All of that a part of our discussion this weekend, and indicating along the way that none of this is a source of celebration. It is indeed tragedy. I mentioned just previously, tragedies like Macbeth and Othello and Richard III. There is something Shakespearean about all of this, a tragedy for America. As always, we appreciate calls and comments. I'm going to take some of those right now before we go on to other subject matter. Let's hear first from Joe. Joe, glad to have you with us this weekend on Amicus. Yes. Right. Joe, thank you as always for that insightful comment. And indeed, there's a reason to be concerned about two-tier justice. When you've got the Speaker of the House of Representatives inserting himself in this judicial process, which, as I've indicated, full of integrity and decency and propriety along the way, suggesting not only that it is suspect and that it is corrupt, but then indicating, Joe, as you repeated as well, that I'm just going to pick up the phone. And I have, in fact, spoken to Supreme Court justices. Don't worry, this will be taken care of. They're very concerned about this as well. Wildly, wildly inappropriate. And again, one of the things I'm going to be doing in just a few moments or so is once again advocating that we reach out to these people and tell them individually, as citizens of America, the Speaker is the Speaker for all of us, that he shouldn't be doing this. Susan Collins is a United States Senator. Donald Trump may be the next president of the United States of America. All these comments suggesting that the rule of law is not existent in America, or at least it's not existent for him, when in fact just the opposite is true. And the two-tiered system that you're suggesting, which again is that Donald Trump maybe, presumably has the financial resources to hire lawyers and defend himself. An awful lot of people out there, Joe, as you've just indicated, do not have those accesses to the Susan Collinses and the Mike Johnsons. And the Supreme Court of the United States of America, two-tiered justice indeed, if indeed we are to believe these people on Capitol Hill. Secondarily, I agree entirely that when we talk about deterrence, there's that word once again. Deterrence not only specific as to Donald Trump, but also generally to people who might engage in similar kinds of things. And yes, there are quite literally hundreds of these kinds of prosecutions all the time, not just in New York, but in states around the nation. Don't do this. Why? Because you will suffer the same kind of thing that Donald Trump suffered as a result of his criminal conduct. All of that has got to animate the judge's sentence here. And although, again, the statistics indicate that people who suffer these first kinds of criminal convictions do not traditionally suffer any kind of incarcerative sentence, here's a situation where Juan Merchan, based upon recommendations and a lack of remorse by this defendant, statements made by this defendant suggesting the process is a sham, he may in fact do it. And my own view is just like yours, Joe, that there should be some period, however limited, of Donald Trump in an incarcerative detention type setting to send the message not only to him to knock it off, to deter him from doing this, but also to do others the same sort of messaging. Very important comments to make and to articulate. Appreciate as well call in from Dick this weekend. Dick, appreciate your calling in from Madison. And Dick, appropriate comments all across the board once again. You know, as you indicated, this notion that we've got these people out there who are describing this appropriate event in a way that gives people reason to doubt the seriousness of government here generally and the problems that are existing when in fact they're not. I agree entirely when it comes to the kinds of things that America should be responding to. We should be outraged by those kinds of messages. Again, what you do is by Governor Hogan, you can say that you may in fact disagree if you've analyzed the facts yourself. You may disagree with the verdict, but you respect the process and you respect the fact that 12 people in that trial courtroom witnessing what the witnesses were testifying to, looked at the documents. You respect that process enough to say, I embrace the verdict, I respect it. I also embrace the sentencing prospect. I embrace the appellate prospects here, all those kinds of things. But I don't indicate that that very process upon which our nation's been built for more than 240 years is suspect and should no longer be trusted. That's the great danger. And that is, Nick, as you said, just in the middle of this campaign. That's why we can't tolerate this kind of thing and need to respond emphatically. We have talked at great length about the Supreme Court and the kinds of things that the Supreme Court is wrestling with these days. One of the things that we've talked about in the past is the possibility of writing to the Supreme Court and telling them how we feel about some of the ethics issues along the way. Last week, a caller said, "What is that address, Jim?" And I've got it for you now. If you are interested in writing to Chief Justice John Roberts or any of the associate justices, including but not limited to Sam Alito and Clarence Thomas and all the others, here's the address. It's 1 First Street, Northeast Washington, D.C., 20543. When we come back, more Rule of Law on this Amicus weekend.
I'm assuming we're done with Trump now.
What's that?
I'm assuming we're finally done.
We are done, right? Yeah.
2 segments left. This
Okay.
upcoming one is the longer one.
Okay. So it should be. They should be calling in right about now. So and if and you just throw them up here. And I'll take them. If they don't, I've got plenty of other material to get to. So we'll see if they come in.
Eye out for them,
okay,
so,
great.
I'll put them up on there.
Okay, great,
right
good,
away. So.
Terrific. Yeah, I'll do some other things until they call in here, and then I'm going to do a little bit of background, and then we'll pull them up. So good. Thanks, Max.
Okay, awesome. Sounds good. They'll probably,
This is Amicus Solar Review. My name is Jim Santelle. This is the second hour of our weekend broadcast, focusing, as always, on the rule of law, on the delivery of justice, and the operations of government in our nation and beyond. A part of that, of course, focusing, as always, upon the courts. And in our remaining time this weekend, I'm going to talk a little bit about the Supreme Court. I'm going to talk about a federal district court decision some 10 years ago that changed the way in which we think about human beings in America and in our state of Wisconsin. Have some special guests we're going to be calling in and talking with us about that major event. Just this past week, the Supreme Court, again, in the midst of its time period when it begins to issue some of these major decisions, issued a major case, a major opinion in a case called NRA versus Vulo. Supreme Court sided with the National Rifle Association on Thursday, finding that the group could in fact litigate a First Amendment claim against a New York state official who had encouraged companies to stop doing business with it after that remarkable, horrific, terrible 2018 shooting in Parkland, Florida. Justice Sonia Sotomayor, writing for a unanimous court, 9-0 here, found that the NRA had in fact claimed a plausible cause of action, plausibly claimed a violation of the First Amendment, not finding it, but arguing and maintaining, stating that indeed the NRA does have a claim that it can litigate on the lower courts, and reversing an appeals court and sending the case back for those further proceedings. Although a government official, she said, is allowed to share her views freely and criticize particular beliefs, the Supreme Court, Justice Sonia Sotomayor, again writing, that official may not use the power of the state to punish or suppress disfavored expression. This case, of course, one of two major cases this term, which we've talked about, in which the justices are wrestling with when government advocacy by various entities crosses a constitutional line into coercion. The other case is also out there, is involving Murphy versus Missouri. It also has to do with whether or not the Biden administration efforts to stop the disinformation placement upon platforms, social media platforms, is appropriate. Likely a completely different result in that case, the Supreme Court in Murphy, indicating that probably will support that advocacy, but not when it's coercive, not when it is attempting to do something that expresses power against an agency, in this case, the NRA. NRA versus Vulo, a major case, a unanimous decision just this past week coming out of the United States Supreme Court. Other major rule of law snapshots, things as we know are going on right now in our world. We know recently coming out of South Africa that the voting there has basically determined the African National Congress, which has been the party in power, the parliamentary authority for about 30 years, ever since apartheid was brought down there, has lost its majority for the first time in 30 years. Lots to look at there, receiving just about over 40% in the election, well short of the majority it needed, and that's held to continue to operate there as the leading governmental power, has to put together a coalition government. Fascinating issues there with respect to the rule of law and justice as well. And we also know that to our immediate south in the nation of Mexico, tomorrow, the voters there in the country of Mexico are going to the polls to elect their next president. Almost certainly, they're going to elect a woman named Claudia Sheinbaum. She's a PhD. She's got a shared Nobel Peace Prize. The first woman elected to lead Mexico City, her nation's capital, one of the largest cities in the Western Hemisphere. Almost certainly going to be elected on Sunday, that is this weekend, as the president of Mexico, beating America to the time when a woman can and should be serving in these important positions, not without its controversy. There are lots of things that she is going to be taking on, including the fact that during the course of this election, literally about 36, almost 40 people have been killed in various positions seeking office in Mexico during this very term. A lot of violence there as well, with which she's also going to have to contest. That election this weekend in Mexico, again, is a part of our rule of law snapshots. We are anticipating not only this month, but throughout the year, of course, further focus on this broadcast and others focusing upon human rights and civil rights. This is Pride Month in America, that time when we specifically acknowledge the privacy rights, same-sex marriage, relationships that are important across the board. And indeed, today on this broadcast and coming up this weekend in particular at Pride Fest in Milwaukee, a special celebration of the 10-year anniversary of a major decision coming out of a federal district court and affirmed by an appellate court here in the Seventh Circuit, a case called Wolf versus Walker, federal lawsuit filed in February of 2014, decided in June of 2014, 10 years ago, and challenging at that time Wisconsin's refusal to grant marriage licenses to same-sex couples, refusal to recognize same-sex marriages established in other jurisdictions, and some related statutes. In June of 2014, Judge Barbara Crabb, who is in the U.S. District Court for the Western District of Wisconsin, ruled for the plaintiffs. And in that particular ruling, she said in particular that this kind of discrimination, sexual orientation discrimination, is subjected to heightened scrutiny under the Equal Protection Clause, under the long-established rules and regulations, and found that indeed that the state's same-sex marriage ban must be substantially related to an important government objective to survive. It does not survive. And in this case, Judge Barbara Crabb finding and affirming the right of same-sex couples to marry in the state of Wisconsin. This happening also, of course, while the federal Supreme Court wrestling with cases like Windsor and Obergefell, that, of course, in other times right around the same period, the federal court ultimately likewise affirming the same thing under our Constitution. Wisconsin, again, based upon this federal case affirming the right of same-sex couples to marry in the state. We celebrate and we recognize this week, this month, as always, the 10-year anniversary of that major decision, and we are delighted. We are honored today and this weekend on our broadcast to have some of the plaintiffs in that case from 10 years ago. I'm going to talk with them in the remaining time that we have here on our broadcast. I'm going to begin with two of the plaintiffs, and their names are Pam Kleiss and Salud Garcia of Madison. Pam and Salud, we're delighted to have you with us today. Welcome to Amicus, a law review. Salud and Pam, again, delighted to have you with us. I've done a very much abbreviated version of the litigation in which you were involved long before 10 years ago, but certainly much in your mind and our mind again as we acknowledge and celebrate the 10-year anniversary of what you and others as plaintiffs accomplished by advocating on behalf of civil rights here in the state of Wisconsin. I've argued throughout the country, leading to the federal acknowledgement also of same-sex rights. Let me begin by asking the two of you, What animated you at the time? Can you go back 10 years ago and tell us what prompted you to join this lawsuit and say, yes, we want to be heard. We want to affirm this basic human right. What prompted you to make that major decision that had to be the subject of an awful lot of deliberation before you made it? Yes. Absolutely. And so, we talk generally about privacy rights, but that is a very broad umbrella, right? That's the point that you're making, that yes, it is about same-sex relationships and the legitimacy of all those personal interactions. Also, the practical implications just talked about, again, health insurance, your family. It's broader than just this, right? And I suspect that too animated your interest in being a part of this. It's beyond just this issue. As important as this is, it has implications well beyond the specifics of this lawsuit.
In our case, we moved to Wisconsin from Seattle, where we had a recognized domestic partnership, and where our child was born, and we were able to adopt our child legally. In
What she means is I was able to adopt my
Yes.
child
Right,
legally.
right.
I became a legal parent,
Right.
not just,
Mhm.
a hanger-on.
Right, and through that adoption, we realized that was the sole legal document that tied the three of us together.
Right,
Mhm.
right.
And we kept that document, especially, it wasn't laminated or anything
Mhm.
like that, but we thought as we travel, like on vacation or something, this is the one document that shows that Salud had a right to our child's healthcare decision-making, for example, or anything like that. So as we faced new jobs in Wisconsin, as we realized that Salud's employer would not budge on giving me health insurance,
Mhm.
despite having other team members, their spouses and people that were at home caring for their children were able to extend that privilege to their spouses. So it just became more and more frustrating to have to make do and figure out different ways to do things when for all extent and purposes, we were a family living in a domestic relationship that is honored in this country in many, many ways. And we didn't want this have to be an employer dependent
Right,
Right.
right.
or state dependent, or we had to extend to other people's consciousness to try and get these rights.
Right.
They should be and would be
Mhm.
embedded.
Right.
Absolutely.
So
So, as I listen to you talk, I'm also
inspired, as I suspect all of our listeners are as well, by the gravity of her decision not only to become involved in this lawsuit. There had to be things, we talk a lot on this broadcast about the processes of trials and the processes of
Mhm.
courts and depositions, which I know you were subject to, and the tussle. And this is no easy thing. I wonder if you could chat with us a little bit about the challenges that you undertook in addressing the issues that you're just describing and how you overcame those, both personally, individually, as a family, even emotionally. What did that look like, the struggle itself? Can you comment about that a bit?
Um, I'm not quite sure I understand your question, but let's start from the very beginning with our child's birth. Our child was born very early, and Pam had to be in the hospital on bed rest for a week prior to that. And in Seattle is a pretty liberal city. And so at first everything, it looked like the hospital was going to be good to us and treat us like a family. And on the day of Jesse's birth, which was completely unexpected, I was supposed to get a little bracelet that said I was Jesse's parent. And what happened was that the nurse who was supposed to do that, or the assistant or whatever, wouldn't give it to me because I wasn't a family member.
Mm.
Meanwhile, Pam is bleeding, and so they're not able to stop bleeding, so they have to take her into an operating room. And
Pam, I'm going to interrupt you right now just because I need to do a little bit of a break here. I want you to stay on the line and finish this.
Okay.
This is Amicus, hello review. My name, Jim Santelle, talking right now with Salud Garcia and Pam Kleiss of Madison, talking about the things that prompted them to file and engage in this lawsuit that resulted in the recognition by a federal court here in Wisconsin, same-sex marriage in Wisconsin. And right before we broke necessarily, Pam and Salud, you were talking about the specific medical situation with Jesse's birth that prompted all of this. Go ahead and give us more of that story.
Okay. So in that instant, I could have lost everything because we were not married. If Pam had died, I'm sure her parents would have taken Jesse and never let me see him again. And I would have been totally bereft. So fortunately, that didn't happen. One of my brother-in-laws was able to talk the staff into letting me have the bracelet. Then when we came to Wisconsin, I worked for an organization for 10 years, and in that 10 years, they never extended domestic partner benefits, even though other places in Wisconsin did. So for 10 years, when Pam was at home caring for our child, because our child had special needs, we couldn't put Jesse in a regular preschool. We didn't feel comfortable with that. She had little to no health care, even though I had peers at my organization who, same situation, spouse at home taking care of the kids, they had health insurance, they had all the other benefits of marriage. It really made me so angry. And I was telling a friend of mine who works for the ACLU when the lawsuit first started about our experience and how angry I was. And I was, when the marriage amendment first went through the legislature, I cried. I couldn't believe that this was happening. It was so blatantly discriminatory, especially when the gay and lesbian community wasn't pushing for marriage in Wisconsin. I don't, it was just like typical bullying. And we were so furious. And when the ACLU reached out and asked if we'd be plaintiffs, both of us were kind of in tentative. Pam had just started a job, and I was in between jobs. And, there was some possibility that maybe people would then know our names and there'd be backlash and maybe I wouldn't be able to find a job and Pam would lose her job. But we still said, no, this is wrong.
And
We
wanted
have
to
do what we
pursue
can.
this, right? And
Right.
right.
And,
And Pam and Salute, we were
go
going to
ahead,
be talking more about this at Pride Fest in Milwaukee this coming Friday afternoon and evening, a special program not only celebrating what you have done, but also the other plaintiffs. I'm proud to say I'm a part of,
Right.
of that presentation along with Larry Dupuy, who was one of your lawyers at the time. We're going to be talking about all of this, right? And I want to thank you so much. I'm going to talk to Virginia next in our remaining moments here, so I'm going to complete our conversation, but look for more of that. We're going to bring Virginia in, who's also one of your plaintiffs, Virginia Wolf. But Pam and Salud, thank you so much for being with me. Virginia, thank you for waiting. We're talking, obviously, about your advocacy and appreciate your being on the line, telling us all about what motivated you to be a part of this plaintiff class 10 years ago, and even more than that, that brought about this significant result for same-sex marriage and civil rights generally in Wisconsin. Talk with me about what motivated you to become involved in all of this.
Well, I think originally the worst thing that happened to us was that I was in the emergency room and the nurse wouldn't let Carol be with me, and I was thinking that I was having a heart attack, and finally I just started screaming and throwing a fit. Then the nurse got frightened, and so she finally did allow Carol into the emergency room.
And that's Carol Schumacher, your partner, right? Carol Schumacher, right?
Carol Schumacher,
also a plaintiff
partner.
in this case, right? Go ahead. Yes. Yeah.
Right.
Yeah.
And after that, we did all sorts of things. We got wills, we got power of attorney for health care, power of attorney for finances, and, we thought we were protected. But then I almost drowned. Carol saved me, but, she wasn't a relative. So the question of whether or not she could get in the ambulance with me and go to the hospital, had she not known one of the EMTs, we wouldn't have succeeded in having her be with me.
Right.
So
Stunning, shocking,
we had we had experiences like this over and over again. And Carol couldn't get my Social Security. We're both retired, we're both older, and she couldn't get my Social Security as a wife normally could. When she turned before she turned 65, and we started. We were in the domestic partnerships suit. We went in 2004 and asked for a marriage license from the county. So we've been doing this kind of stuff for a long time for pretty obvious reasons. And of course, we're particularly fearful because now we're in the last stages of life, and what if something happens to us? And who can, this is all in our thought as we were
basic human rights, basic concerns of every living human being, right?
Yeah, I want to tell you, Jim, there's 200 rights and protections in Wisconsin. There's over 1,100 federal rights that we didn't have until we got married. So that's a lot of rights.
That is. And I assume that you're going to be joining. Perhaps Carol's going to join, but also Salud, Pam, others at Pride Fest this coming weekend, Friday in particular. This wonderful event. I assume you'll be able to tell your stories more and even animate us more to be concerned not only about the future, but also where we are right now, right? And being a part of that initiative too.
The present has really been such a relief for us because now, we have all of those benefits and so forth. But I am really worried about the future. I mean, with Clarence Thomas's statement about
Yes.
revisiting
And
same-sex
Dobbs
marriage,
revisiting privacy rights, right? Exactly. Same-sex marriage,
right, and I mean, just
contraception, right?
or Tennessee saying that you can discriminate on the grounds of religion. I mean, there's a lot of stuff going on right now that's really scary. And
Absolutely.
So, yeah.
But Pam,
But also, I want to say this too: we're gonna celebrate
yes, I was
same-sex marriages too. We're gonna have
exactly.
a renewal of vows.
Yes,
So
renewal of
that'll be
vows on the campus there at Pride Fest at 7 o'clock on Friday, June 7th. You, Virginia, Carol's going to be there. Salud, Pam, and all the other plaintiffs also going to be there to celebrate and renew vows. I'm also very pleased that you've invited me and Larry to talk about the present and the future of not only privacy rights but same-sex rights. What a wonderful time to be thoughtful about where we are and where we need to be in the future as well. And appreciate so much your being a part of this. Looking forward to being with you, Virginia, being with Carol, Salud, Pam, and all of your co-plaintiffs at this time of historical recognition and also a commission for the future. Thank you so much, Virginia, being with me. I'm looking forward to seeing you and visiting with you on Friday as well as all of the other plaintiffs and others who are interested in this issue. As always on our broadcast this weekend, we continue to engage in discussion about the rule of law, about justice, democracy in America. That continues next week, our 100th broadcast.